Start. Learned counsel appearing for the respondent's waive service, full stop. The petition is filed under section 482 of criminal procedure in bracket, in short, the code for quashing the FIR lodged by the respondents number 2 for the alleged offences punishable under sections 498A, 306 read with section 114 of IPC, alleging that the daughter of the complainant was subjected to cruelty and driven to commit suicide, full stop. The FIR was lodged on the very next day of death of the deceased, that is 13/06/2008, and present petition is filed on 26/08/2008, annexing a deed of compromise dated 08/07/2008, full stop. It is stated in the compromise deed that the original complaint and the accused persons have entered into a compromise by intervention of elders and looking to the larger interest of 3 minor children and their upbringing, full stop. It is stipulated in the compromise deed that the complaint would be required to reply to all relevant questions in any court in such manner that the accused persons would not face any difficulty, and he has to remain present in the court so as to help the accused persons, full stop, para. It was jointly submitted by learned counsel appearing for the petitioner and learned counsel appearing for the complainant that both the parties have entered into a genuine settlement on account of complainant realizing that there was no substance in the complaint, which was filed in a hurry and out of emotional outburst, and this court was required to quash the proceeding in the interest of justice in exercise of its extraordinary jurisdiction under section 482 of CRPC, full stop. Learned counsel relied upon the judgment of Supreme Court in the case of B.S. Joshi versus State of Haryana, reported in bracket 2003 for SCC 675, in which the Supreme Court has held that the High Court, in exercise of inherent powers, can quash criminal proceedings of FIR or complaint, and section 320 of CRPC does not limit or affect powers under section 482 of CRPC, full stop. The court should ordinarily accept the terms of compromise even in criminal proceedings, as keeping the matter alive with no possibility of a result in favor of the prosecution is a luxury which the courts, grossly overburdened as they are, cannot afford, and that the time so saved can be utilized in deciding more effective and meaningful litigation, full stop. This is a common sense approach to the matter based on the ground of realities and bereft of the technicalities of the law, full stop, para. In the facts of the present case, it was stated at bar that genuineness of the compromise settled upon by the parties and absence of any inducement, duress or malafide was verified by the court on earlier occasion by personally calling the investigating officer, before whom a statement in consonance with the compromise was also independently recorded, full stop. It was, therefore, submitted that this was one of those genuine cases in which the compromise was required to accepted for terminating the criminal proceedings in the interest of justice, even if the court may not accept as a general proposition that in all cases of the accused persons settling with the complainant, The court must exercise its powers under section 482 of CRPC full stop over.